The Honourable David Parker.
Thank you, Mr Speaker. Can I begin by responding to Marama Fox's contribution, the vast majority of which I agreed with, and thank you for that contribution, Marama Fox. But there was one mistake I think that was made, and that was that if I understood your contribution to be correct, you said that if someone had been in a detention centre for 6 months following their imprisonment, they wouldn't be caught by the returning prisoner provisions of this bill. That's actually not correct. The bill at section or clause 17 subsection 2 says that that 6-month period runs from the release of custody, and release of custody means if a person is detained in an immigration or other facility following release from prison, the date of the release from the immigration or other facility, not the release from prison. I'm pretty sure, in fact I am sure I'm right on that, and I've just read from the relevant subsection of the bill. I don't say that to criticise the member, but to highlight the problems that we have in Parliament when we pass legislation under urgency, because it's understandable that members who make contributions to this debate can't be expected to get their head around all of the finer detail and indeed around the effect of important provisions like that. So in respect of that, I take from your comment that you would think that that's going too far in respect of this legislation, and that underscores the fact that maybe we are. I've also pointed out other examples of where we might be going too far, and I've pointed out other examples where we're not going far enough to protect the interests of New Zealanders. And if I could traverse the issue that we've had discussion with the Minister and the Chair about earlier, about whether you can get the required information from someone who returned to New Zealand having had a conviction overseas that's not necessarily known to the New Zealand authorities, but which I think is an appropriate thing that the New Zealand authorities should be able to learn from the offender if they haven't learned it from Interpol or some other country. Now, this bill does not allow the police at some later stage to require someone who is convicted and has served a sentence for a serious offence overseas to have to tell the New Zealand authorities about it if they ask them about it. Now, the Minister said that that will never be a problem because they can get that information from overseas authorities. I'm sorry, that is naive and untrue. It's just not right. You know, take, for example, someone who was in Syria, for example. Do we really think that we could be getting proper information from Syria as to what convictions a returning New Zealander might have had whilst in Syria some years ago? It's fanciful. It's laughable. It's also true in respect of various other African and Asian regimes. It's just not believable. So we have still the possibility of people returning from those jurisdictions, and these won't be common occurrences, but they're nonetheless things that we can think of that could occur and we should have a legislative fix for, who return to New Zealand and there's no record in the New Zealand system of those persons overseas offending. So what happens when, for example, someone is investigated following a crime that they're alleged to be involved with in New Zealand? Now, I've used the example, and these are distasteful examples that we don't like to talk about, and I don't want to ramp them up because I don't like trying to spawn fear in society, and I'm not trying to do so here. But it is true that some sex offenders against children have a recurrent problem. It's actually one of the reasons why the likes of Australia wants to get rid of them out of there and send them back here. Now, if they've come from another country, not like Australia, where you could get that information, I would want there to be a duty upon the person to say, yes, I was in Syria lived there for 5 years, and that's why, or 20 years. That's why there's no record of me being in New Zealand because I've been overseas for 20 years, but, that person should have a duty to disclose their convictions. Now, we can't have those discussions at Select Committee. Neither can we have the discussions, the submissions that we would get from the Law Society or from Rape Crisis, even the Sensible Sentencing Trust, who I generally abhor as an organisation for their hypocrisy. and for their wrong-headedness, their hypocrisy being shown by events with David Garrett when he was here, having backed him for a discharge without conviction and a name suppression when they generally opposed both for criminals after he had been found to have stolen the identity of a dead baby in order as part of his passport fraud. That sort of hypocrisy annoys me. But nonetheless, I respect their right in civil society to make submissions on legislation. So I would defend even the right of the Sensible Sentencing Trust to come along and say that this legislation doesn't go far enough, if that was of their view. We've heard from Marama Fox and others about how PARS, and I would also say the Howard League for Penal Reform, they've got a relevant interest in these things. And it might not be directly in respect of this legislation, because this is about management and information, but if there is no parallel process elsewhere in government dealing with the need to help these people reintegrate and minimise the risk that they will reoffend, well, that's actually something that would be highlighted by those submissions to Select Committee, and that's one of the reasons we have these processes. I want to say, Sir, why all of these things go to the underlying principle of why it was that the Labor Party suggested that we have a parallel process with a sunset clause for this legislation, where it was a very simple process. We were suggesting it wouldn't have elongated this process in this House. We could have had two bills being considered at the same time. The parties of Parliament would have agreed to that through the Business Committee. One of the bills would have been taken through all three stages under urgency, and it would have had a sunset clause or an end date of a year, say. We were flexible as to the date. And then the second form of that bill would have passed only its first reading. It would have commenced at the end date of the first version of the bill, and it would have gone to Select Committee. And through that, we could have advertised tomorrow, and we could have heard about from submitters, and we could have taken the time to actually get this legislation right. Mr. Speaker, I don't think we've even fixed the grammatical error that's at Clause 7 of the bill. It was pointed out by David Shearer to me and raised by me in the first reading debate. It says who is returning offender. It means who is a returning offender. They've missed out an a. Well, that sort of error should be fixed, and there will be other mistakes in this bill that could be of import as to what the legislation actually means. We haven't had the time to deal with that. It would have been fixed at Select Committee if they had chosen the process that we had suggested. Now, the idea that a review via a Select Committee established is an answer, I don't think that's right. Select Committees, they don't have to hear submissions. The Select Committee are controlled by the government. This Select Committee will have a majority of government members. They can just say if this is too much of an embarrassment or they don't want this particular item coming up, they can actually cause that inquiry to be very short. They don't need to hear submissions from the public. They don't need to do a proper job. And if it's too embarrassing, they probably won't. Governments often act like that. The reason that we have multi-stages of processes, committee stage, sometime after a Select Committee's looked at it, is actually to make better legislation. And we had offered the government a practical way to achieve that, and they've thumbed their nose at us, and I think it actually shows how scant regard the government, including the Minister, Amy Adams, has for proper processes and getting the balance right between civil liberties and civil individual liberties and protecting the rights of public, both of which are relevant on this occasion. Finally, can I end by saying I am pretty fed up with the position that the Australian government takes in respect of New Zealanders living there. As others have said earlier in this debate, it is true that we deport some serious criminals back to Australia, but it is also true that if people live in a country from close after their birth and they are effectively an Australian, then why is it that we are not ensuring that those people in Australia have all the rights of Australians, including the right to live in their country after they are convicted of less serious offences? Why is it that they can't get proper social support? They pay for social insurance like disability insurance. They actually pay and they don't get it. They're excluded from the scheme even though they pay for it. They can't get decent support as students, women who break up from their partners and children are in the country. They can't take their country out of their children out of the country back to New Zealand because of the Hague Convention, and yet they can't get the supports they need in order to maintain themselves and their children while they're there. Mr. Speaker, those things should be properly being addressed by the government. They're not. We don't hear the government standing up for the rights of New Zealanders in that regard. Final point, sir. I am still offended by the Prime Minister's comments about us supporting rapists last week. A low point in this House, a low point for the Prime Minister, and particularly galling given that clearance and conviction rates in respect of rapes that do occur in New Zealand are decreasing under the Police Department under his watch.
Chris.